Hi, and good morning. Today we're here with Christine Spagnoli, a partner of the firm of Green, Burlett and Wheeler. Christine graduated from Loyola Law School after attended UCLA undergrad and spent some time in the political arena. She specializes in trials of product liability and other catastrophic injured cases. It's great to have you here today, Christine. It's been a while, but thanks for coming.
Thanks, Brian. Happy to be here.
So I'd like to start off talking about, just tell us generally, what does your practice consist of and what kind of things are you doing on a day-to-day basis?
Well, for the past 20 years or so, I've focused primarily on cars and tires, automotive products liability, defects, catastrophic injury cases, mostly involving fuel systems, fires, tire failures, rollovers, crashworthiness. Those kind of cases.
And in those kind of cases, you're suing primarily either the manufacturer, distributor, somebody involved in the chain of these various products.
Right. Ford, General Motors, Chrysler.
Small companies. And I would assume that those companies have pretty good lawyers that know what they're doing in defending this case. What's your experience?
Well, typically, you see the same law firms. It's repeat business for them, and they have specialties. They have firms that specialize in the fire cases. They have firms that specialize in tires. And many of the lawyers on the other side are also engineers. And that creates a bigger challenge because you really have to know the technical issues in these cases in order to get around the defenses and understand why a product failed or how it could be designed better.
You know, that's a great idea. Let's talk about that. What are the common defenses, no matter what the product liability case is that you see consistently the defendants raising?
Well, the one that's probably the biggest hurdle for most automotive product liability cases, and it's even true in medical devices and drugs, is that there's a government standard that sets a bar, and the manufacturer claims, well, we passed the government test, so we must be safe.
How do we know they passed the test? What's done in that?
Well, in the auto arena in particular, there are fuel system safety standards, or Federal Motor Vehicle Safety Standards, FMVSS, and those are performance requirements. So the government says in order to sell your truck, you have to prove that the gas tank isn't going to leak in a 30-mile-an-hour rear-end crash. And in order to do that, you have to run a test. So the manufacturers take the performance requirements and they run the tests internally. And then
there somebody from the supervising government agency watching this going on?
Never. No.
How do we know that what they're reporting is accurate?
Well, this is the way that we attack the reliability of these tests, is that manufacturers do what's called self-certification. They run their tests, and when they think they've complied and they meet the standard, they sign off to the government and say, oh, we've met the standard, we've run the tests. They don't have to turn over the tests. They don't have to prove it. The government doesn't test the vehicles themselves, except for in a very few exceptions. There are some tests that the government runs, but it's more of a sample.
But they don't have a staff of engineers and test runners and
right.
people reviewing this data at the government.
Very, very, very limited staff at the National Highway Transportation Safety Administration, NHTSA we call it. They can't compete.
And I'd also think in light of all the budget cuts we continue to see, putting more vigilance in supervision of auto manufacturers is probably not high on the list.
It's very low on the list, and particularly in this administration, there's not even a NHTSA administrator right now. There's no boss.
So there's nobody
in Washington.
There's no one guarding this cage.
Right. And part of the other problem is too, in over the last 30 or 40 years, people who worked in the government as a regulator, they leave. It's a revolving door. They leave and go to work for the manufacturer. So that there's a lot of crossover. And so really the federal agency has been very friendly to the manufacturers. So we can't really count on the government to catch problems when they occur.
Well, for example, the standards, the FMVSS standards, you mentioned the fuel system standard 209. When was the last time that was changed?
Well, there was a period of time that all the standards came about in the early 70s. And for 30 plus years, most of them didn't get changed. Recently, well, when I say recently, the Ford Firestone example, or the calamity of all those people who died and were injured because of failed tires on Ford Explorers, that led to Congress actually telling the government, you have to update the standards, at least in the tire world. And so that did happen. And in the tire arena, there was a new standard in 2007. There hadn't been an update since the 70s. In the fuel system, we finally saw an upgrade in the mid 2000s, which, because of that, we're not seeing as many fuel-fed fires when cars are in crashes. So the government standards really lag the innovation in the industry.
The real world.
Correct. Yeah.
Okay, so I want to talk a little bit about you. Recently were in a trial in Florida.
Right.
You're a California lawyer, but you went to Florida. I believe it was in a 15-passenger van. I know you've done many of those cases.
Right.
So let's use that as a backdrop.
Sure.
So, okay, first question. Going out of town to do a trial, what is that like? What is that experience? You don't have your office. You're not at home. You're living away from home. You're probably not able to come home that often during the trial, being it's 5 or 6 hour flight away. What is that like?
Well, it's a challenge, but in the Florida case, I was there a month. I did not come home. It was too hard to leave court, go catch a flight, and come back and literally have one day at home. So I stayed there. I was in a nice motel, basically, in Newport Richey, Florida, which is not,
it's not Palm Beach.
It's not Miami. There wasn't a lot happening in Newport Richey. It was a very suburban community on the east coast of Florida, in north of Tampa. And spending a month there, you get tired of being in the same room. You go from the hotel to the courthouse and back, and that's pretty much it.
Same food, you get tired of the food and the people.
Right.
But
I had a good support team. I was working with a law firm that is very, it was a big firm. They had a lot of resources. They put a lot of good people in it. We had a war room set up in the hotel.
Well, I heard that. What is a war room?
It's our meeting place. It's where the boxes are with all the exhibits. It's where the printers are. It's where the computers are. It's where the staplers are. It's where you go to, put your little package together for the next day and make sure that your PowerPoint works.
About your snacks.
And your snacks. Oh yeah. We had our beverages and our snacks, and we had the pizza delivered there, and met with experts. It's somewhere that hopefully you can have some privacy and
kind of like your office at the location.
Right, and have strategy sessions with the other lawyers.
So this trial took approximately 1 month.
Right.
And it was against Ford?
It was against Ford Motor Company and the First Baptist Church of Newport Richey, which was the owner of the van.
And I assume that Ford was probably trying to say that the church did some things that they shouldn't have done.
Well, actually, quite interestingly, Ford was going for the home run. It was all our client's fault and nobody else's fault. It wasn't the van's fault. It wasn't the church's fault.
Driver error.
No, our client was a passenger. She was a church volunteer who was taking a group of kids to go on a church retreat and was a passenger in the church van. She and the other folks got in at 5 a.m, and when she got in her seat, she went to put her seatbelt on, and her buckle was not on the seat because the buckles fall through the cracks in those seats. So she didn't have a seatbelt buckle. She was sitting in the van asleep, and the driver of the van experienced a tread separation on a tire, lost control, the van rolled over, and she was ejected. And so Ford said, gee, if she'd only had her seatbelt on, she would have lived and we wouldn't be here.
And did the other people get injured that had seatbelts
on? There was nobody wearing a seatbelt except for one of the kids. And the driver was not wearing a seatbelt. He was very heavy and it didn't fit. And he was ejected and killed as well. And his case had settled. Everybody else had resolved their cases. There were other injuries of kids primarily who'd been ejected. But this case, Ford chose to take to trial and the church took to trial because They felt that they had a clean defense on the no seatbelt.
And in Florida, comparative negligence is a pure comparative state?
No, it's a percentage of fault. So they pay their share of fault plus any economic damages.
So
So
similar to California.
very similar, very similar.
Okay. So what were the big defenses? Just that you didn't wear your seatbelt and you're required by law to do that? And if you had, you wouldn't have been hurt?
Well, actually, in Florida, since she was a passenger, the law did not require her to wear a seatbelt. But we made the case.
They're going to think you got to have your seatbelt.
Sure. And that was when we were picking the jury. That was one of the two issues that primarily got people thrown off for cause, because most in Florida, they have a pretty low bar to say that someone should be off because they have a preconceived idea that would not make them a fair juror. And in the case of the seatbelt, many people raised their hand and said, I have already decided the case. If she wasn't wearing a seatbelt, it's her fault. So we cleared a lot of those people out.
So you just brought it right out and addressed it in front with the
Absolutely.
jurors. Could you find a defect in a vehicle if you heard the person bringing the case wasn't wearing their seatbelt?
Right.
Some people said, no way.
Right.
And no seatbelt, end of story.
Right. And then we made the actual availability of the seatbelt one of the defect issues in the case, because the way these Ford vans were designed right up until the last few years, the benches in the 15-passenger vans come out so that you can make it a cargo van. They're trying to do a 2-for-1 deal. And when you take out the seats, the belts come with it. The buckles that are attached to the legs of the seat come with it. So there's a little hole that the buckles thread through. And when they fall through, someone gets in, it's not there. It's not readily available.
So you were able to work into your case part of the theory, which would excuse the fact that your client wasn't wearing the seatbelt.
Right. And it was also our theory against the church, because the church had a safety supervisor who was supposed to make sure that when the van left the parking lot, all the seatbelts were functioning. And he told us and told the jury that they were falling through all the time.
So he wasn't really doing what
they weren't doing their job.
So it sounded like you got a pretty good case against the church, harder case against Ford. What did you do, your team, pre-trial, to figure out what you needed to do to sway the jurors? What did you do?
Well, one of the interesting things we did is, because we knew that Ford was going to make the case about the seatbelt, we really started out thinking, well, in many cases, seatbelts don't protect people in rollovers. And so we were going to attack the seatbelt defense by saying, Ford, you can't prove she would have lived, because in rollovers, many people wearing seatbelts get ejected or partially ejected anyway. We decided to change our focus and make the fact that the belt wasn't available an issue for Ford too. And we took their biomechanic expert's deposition, and he conveyed the opinion that if she had been wearing her seatbelt, she would have lived. We adopted his testimony. We got rid of our own expert, and we played the videotape of the defense biomechanic saying if only she'd had her seatbelt on, she would have lived. That became our theory. She needed her seatbelt, and you didn't give her a seatbelt. So Ford, you're partially responsible.
So you took what they thought was the biggest strength in their case, and you made it part of your theory in the case.
We adopted it.
We
adopted their theory.
You commonly do try to embrace or adopt some of the problems in your case?
Absolutely. It's a great way to diffuse issues, to basically stand up and say, we agree. If you'd only done X, this person would still be here. And that becomes your theory of the case. It's kind of hard for them to fight it when they're saying they're agreeing with you. How easy was it for them to make the seatbelts available? That became the focus. We literally had a zip tie example to zip tie the buckles to the seats. It's simple to give her a seatbelt.
And also the church not making sure that all the safety equipment was available. Certainly they were negligent.
Correct. Yeah.
Okay. So what about mock trials or focus groups? Do you commonly do things like that?
Absolutely.
Well,
we do focus groups.
Why do you like it?
Well, it does a couple of things. Number one, I like having the trial run. I like having the opportunity to get up and deliver your opening or present evidence to get comfortable with doing it, so that you're not, for the first time, talking to a jury about your case and kind of stumbling over what is it I want to say here and there. And you can hear the feedback that lets you adjust, what's the strong points, what's the weak points. Doing a focus group, and particularly getting a couple of them done, is that you just hear from people who are coming up with ideas that you maybe never thought of.
Well, isn't it true, generally speaking, that when you're so engrossed as a lawyer working up the case, preparing the case for trial, that it's hard to not maintain that focus and see everything else that's out there?
It is. And the other thing is, too, when you do a focus group, if you do it right, you present yourself a challenge. You either do the defense or you have somebody really good do it, so that it's not a laydown where you're going to win. You want to make it as hard as you can to see where your problems are.
Where your weaknesses are, shore them up. So tell us, so what happened? How did the case turn out?
Well, it turned out great. The jurors were unanimous. We had, aside from the seatbelt, we said that the van itself was defective because it went out of control too easily when you have a rear tire failure, because the long wheelbase and the extra weight in the rear makes it unstable. So the jury found in our client's favor, 31% to Ford, 28% to the church, and 23% to the decedent, and some amount on the tire company, and the verdict was $26 million. So the combined offers in the case before trial between Ford and the church were less than $1 million. So
it turned out
they
okay.
bet bad. They made the wrong call.
And it was worth the long stay. You must have been happy to get home.
Very happy to get home.
Was it humid down there in Florida?
We were there in February, so it wasn't so bad. It was a good time to be in Florida. So quite pleased with the results. Yeah.
Let me summarize and let you tell us. What would you advise young lawyers that want to practice in the area that you do, product liability, catastrophic injury type cases? What should they do to ready themselves for that task?
Well, I think the one thing that, particularly in doing the products liability stuff, is you can't be afraid of the math and the engineering. You have to get your head wrapped around the idea that you have to understand what delta V is and forces are that are involved in collisions, and you can't be afraid of it. And particularly for young women lawyers, I think you have an advantage, because it's older male engineers for the most part that you're facing in these cases, or older male lawyers, and they tend to think that women don't understand these things. And for me, I have found that by being underestimated and not really given credit for understanding the engineering, that you can get a lot more out of these witnesses than if they know you're an engineer and you can figure it out. You don't need to be an engineer, but you need to grasp the concepts and be able to explain them to people in a way that makes sense.
Well, it's one of the ways you do it, by having your expert educate or teach you.
Absolutely. You got to ask what you may think sound like dumb questions in order to make sure you're not stepping into a problem by thinking you've got an answer that helps you and it turns out it doesn't.
Well, thank you for being here. It's been a treat to hear about you and all your success and how to handle these tough, as I would say, cases against some big defendants and making it a safer place for all of us. So thanks so much.
Thanks, Brian, for having me. Appreciate it.